um, embedded within sort of the discriminatory system.
Thank you very much for that. And again, thank you for both witnesses, and I encourage you, if you feel there's anything more you would like to add, to please send us what you need in writing. What we'll do now is start with our second panel. We have one person who's appearing in person, so please advance to the table. We'll have to take a 1 minute because we have one person. I'd have to suspend one person to be tested for sound. Thank you. We have two witnesses with us. Each of the witnesses will have 5 minutes for their introductory comments. I will watch the time carefully as well for the question period. The round will go, we've got another 39 minutes, so we will do our best to get as much information as we can within that time. I will encourage both witnesses, and I think, Mr. Ombudsman, you're aware of this, but the witness on Zoom, who I don't really see at the moment, you'll need to open your camera. Thank you very much. I will encourage you, if there's any further testimony you would like to give us that you don't have a chance to respond to in your introductory remarks or when you are questioned, to please send it to us in writing, because I will have to, unfortunately, watch the time very closely, and we'll end up having to cut people off if the time does not allow it. I will be very kind to raise the 30 seconds mark at 30 seconds. The problem is when people are on video conference, they don't necessarily see that, so I'll have no choice but to interrupt. So let me start off with welcoming both of you, and I will ask Mr. Benjamin Robach, Ombudsman Fédéral des Victimes d'Actes Criminels, to please commence with his introductory remarks for up to 5 minutes.
Merci. Honorable Chairperson and members of the committee, we gather today on the traditional, unceded, unsurrendered territory of the Algonquin Anishinaabe people. In honoring the leadership, strength, and wisdom of Indigenous peoples, we are reminded of the profound importance of respect, autonomy, and protection of the rights and dignity of all people. These principles guide our discussion on coercive control. Intimate partner violence, or IPV, is an epidemic. It transcends geographic, economic, and cultural boundaries, affecting millions of people. The 2018 Canadian Survey of Safety in Public and Private Spaces found that since the age of 15, 6.2 million women and 4.9 million men in Canada have experienced IPV at some point in their life. Section 7 of the Canadian Charter of Rights and Freedoms guarantees the right to life, liberty, and security of the person and the right not to be deprived thereof. Coercive control violates these fundamental rights, permeating experiences of IPV, sexual exploitation, human trafficking, and criminal harassment. It does require intervention. Bill C-332 would criminalize repeat or continuous patterns of coercive control, providing more tools for police to intervene in patterns of abuse. The current incident-based approach to IPV focuses on physical incidents. This can leave police feeling powerless to intervene in some cases where they believe a person is being harmed, or worse, hoping for a future incident of physical violence so they can protect the victim. There are many things we can learn from the criminalization of coercive control in Ireland, Scotland, and England and Wales. The evidentiary burden on survivors can be heavy. Access to electronic devices and communication records is often required to build a case. Training for police, prosecutors, and judges is critical. And risk assessment tools for coercive control can help to identify patterns of behavior. In Canada, recent amendments to the Divorce Act recognize the harmful impacts of coercive and controlling behavior. But proceedings in family court can be messy. Early in 2024, the National Association of Women in the Law sent a letter to the Government of Canada asking to amend the Divorce Act to ban claims of parental alienation in family disputes because of the harmful impact on women. The letter was endorsed by more than 250 feminist organizations. I'm concerned that the criminalization of coercive control could become equally problematic in family court. Even so, domestic homicide reviews in Canada have identified coercive control as a risk factor in several cases of intimate partner homicide with no previous physical violence. And when a survivor leaves an abusive and controlling partner, the criminalization of coercive control may allow them to access provincial compensation programs to help meet their immediate needs. I know the committee has previously studied the topic and heard from our office in addition to experts in the field. I support the criminalization of coercive control, but it must be accompanied by systemic change. I urge the government to respond to the calls of the Mass Casualty Commission by declaring gender-based intimate partner and family violence an epidemic and committing to primary prevention. Some final thoughts. Justice Canada helped develop the HELP toolkit for lawyers after the Divorce Act was amended to include coercive control. It could be updated to reflect changes to the criminal code. Recommend using the definition of intimate partner violence under Section 2 of the criminal code, removing the 2-year time limit after separation, and strengthening victim rights to improve gender equality in the criminal justice system. Thank you for the invitation.
Thank you very much. Welcome to Madame Melanie Omenijo, Women of the Métis Nation. You have up to 5 minutes.
Thank you very much. My name is Melanie Omenijo, and I'm the president of La Femme Chifo Tepimsawak. I'd like to acknowledge that I'm joining you today from Treaty 6 territory in the motherland of the Métis Nation. La Femme Chif is known as a national Indigenous women's organization who is mandated to represent women of the Métis Nation across the Métis Nation motherland. We advocate nationally and internationally for equal treatment, health, well-being of all Métis people with a focus on rights, needs, and priorities of Métis women, youth, children, and 2S LGBTQIA+ Métis people. I'd like to present that we proceed with caution around Bill C-332, an act to amend the criminal code, controlling coercive conduct. Although we are supportive of it in principle, this bill does not go far enough to fully define the act of coercive control and limits it only in terms of intimate partner relationships. To begin with, this puts the burden of proof of significant fear of violence on victims. Victims of coercive control often don't identify what they are experiencing as coercive control, and as it happens slowly and insidiously without, I apologize, just give me 1 sec. I have a pet that wanted to be involved. Coercive control exists beyond a 2-year limit on domestic relationship and does occur between intimate partners who have not agreed to be married. In this light, we recommend that before passing this bill, we must redefine persons who are connected. What this bill also fails to recognize is the unique presentation of violence in the 2S LGBTQIA+ relationships. Regarding sexual exploitation, this act does not include this controlling and coercive conduct within the existing definition. It also does not include children and other family members who may also fall victims. Canada has used as an example the bill passed in the UK around controlling or coercive control. What the UK bill does not consider is the specific implications around Métis women and the strained historical relationship with police and other colonial processes. Indigenous women living at the intersection of multiple sites of oppression face the highest rates of violence of all, especially Indigenous women with current or past child welfare involvement who are living in poverty, are often homeless or unhoused, disabled, or navigating trauma and different substance abuse. About 2/3 of Métis women self-report experiencing physical or sexual violence in their lifetimes. Nearly half are survivors of intimate partner violence. This law relies heavily on the myth that police are the only ones who can keep us safe. It would be part of a police officer's role in determining if a situation should be considered as controlling or coercive conduct. Police attitudes usually focus on the presence of physical violence and focus on specific incidents rather than a pattern of coercive control. This focus also minimizes other forms of violence. Too often in these cases, police do not see survivors as credible victims or witnesses. Rather than assessing protection, survivors are approached with dismissals and suspicion. We also know that Indigenous women are being criminalized for fighting back. This is reflected in the stats showing Indigenous women are 13 and 15 times more likely to be incarcerated than non-Indigenous women and Indigenous men. Indigenous women's incarceration rates in provincial jails are also alarming. In Saskatchewan, Indigenous women are 29 times more likely to be jailed than non-Indigenous women. What is also integral is the enactment of this bill is a robust plan for information sharing, training, and education. This is not limited to police and all players around the justice system, but most importantly for women and gender diverse folks to understand what controlling or coercive control is. The emphasis of risk assessment tools on physical violence and injuries leads to the minimization of non-physical violence. We ask if police officers will be able to assess intimate partner violence situations that do not present physical violence when they arrive on the scene. Will they have enough understanding of the dynamic to see if there are in a presence of potentially harmful situation where coercive control is an issue?
Thank you, Madam. Two comments. One, they were unable to hear you very well. They're asking when you are responding to questions from members, perhaps you can adjust the mic right to your mouth. And I also noticed you had a script. If there's more that you wanted to send us or you wanted to send the script in, that would be valuable as well, and we can distribute that to the members. So let me now move on to the round of questioning, and we will start with Madame Gladue.
Thank you, Chair, and thank you to the witnesses for being here today. We have learned a lot today. When I first heard about this coercive control law, I thought, yeah, we need a law. And I was hearing that, you know, great things happened in the UK and all these other countries. But then today we heard that out of all of the people that come forward on coercive control, only 6% actually get a prosecution going on. And out of the ones that are prosecuted, out of 700 cases that they looked at, there's only 3% that got a conviction. So that really worries me, because if you think about people who have the courage to come forward on coercive control, and then you think of the justice system and the delays, those people are very much at risk from, you know, an escalation of violence from that intimate partner during that period of time. Now, I'm going to start with Mr. Roebuck. You said that the evidentiary burden on victims is high, and you talked a bit about primary prevention. Can you elaborate on those